Now, that is a question been taken first. Why not other most important cases?
My humble submission is practice and procedure. Only the power to regulate the practice and procedure rulemaking vests in the court. It does not vest in the parliament to make the practice and procedure, even if there was something.
یہ بات آپ کر چکے ہیں, نئی بات کر دینا, سوال جواب دینا.
And the law can be challenged on two grounds: that violates fundamental rights or is in violation of some constitutional provision. That is the jurisdiction of this honorable court, not just the violation of the fundamental right, but if the law itself is in violation of some constitutional provision, that can be struck down by this court. So that is the jurisdiction of this court.
اب آپ بتائیں گے میرے سوال, اب آپ عابد صاحب, اب میرے بات کی
High Court has also jurisdiction on 199.
تو میں لکھوں, میں اپنا لکھ دیتا ہوں, it was put to him and he is not answering it.
I'm coming, but my lords,
آپ پہلے ون بائی بیان کر دیجئے.
بہت بہتر سر.
جی
اچھا 184(3) پڑھیں سر پہلے پلیز.
نہیں, مجھے میں نے جو بات کی وہ پڑھ تو 100 دفعہ لیا ہے, میں نے جو آپ کو باتیں بتائیں اس کا جواب, آپ کی رائے کیا ہے؟
میری رائے یہ ہے کہ جی اپیل کا ہماری سٹینڈ بھی ہے کا رائٹ ہونا چاہیے, بٹ اٹ ہیز ٹو بی گیون تھرو اے کانسٹیٹیوشنل.
میں یہ بات نہیں کی تھی, میں نے کہا جتنا استعمال ہوا سب صحیح ہوا.
میں نے جواب بھی آپ نے کہا, میں
آپ سے پوچھ رہا ہوں,
میں کہتا ہوں نہیں, اگر نہیں بھی ہوا ہے صحیح,
اگر پوچھ رہا ہوں, آپ کی کوئی رائے نہیں ہے پریزیڈنٹ آف سپریم کورٹ,
صحیح بھی ہوا ہے غلط بھی ہوا ہے,
نہیں
بھی اپیل ہونی چاہیے. میں کہتا ہوں
آپ یہ میں پوچھ رہا ہوں آپ کی رائے میں, ان یور پرسنل اوپینین, اگر مگر نہ کریں, سیدھی بات کریں نا, آپ کہیں ہوا ہے سارے صحیح ہوا ہے.
میں کہہ رہا ہوں کہ دونوں اچھا بھی ہوا ہے غلط بھی ہوا ہے. جی میرا یہ, اور یہ میں آپ سے آپ کے سوال کا جواب.
ٹھیک ہے. اچھا اب آپ دوسرا سوال سن لیجیے. آپ کا یہ کہنا ہے کہ طریقہ کار غلط ہے, یہی آپ کا آرگیومنٹ ہے نا؟ یہ رائٹ دینا چاہیے مگر آئین کو ترمیم لانے کی, یہ آپ کا بگ موقف ہے.
جی
اچھا اب سنیے, کیونکہ جورسڈکشن نہ ہم بڑھا سکتے ہیں اور نہ پارلیمان بڑھا سکتی ہے, ہم یہ کیس سن کیسے رہے ہیں پھر؟
جی
ہم 184(3) میں سن رہے ہیں نا یہ کیس.
جی
ہم نے جورسڈکشن بڑھا دی یا کہ یہ نہیں بڑھائی؟ کیونکہ جورسڈکشن کرٹیلڈ ہے 184(3) میں دو باتیں, پبلک امپورٹنس اینڈ انفورسمنٹ آف فنڈامنٹل رائٹ. اب کون سی فنڈامنٹل رائٹ انفورس کر رہے ہیں؟ آپ کہہ رہے ہیں یہاں بڑھا دیجئے مگر وہاں نہ بڑھائیے, تو یہاں یہ ہم کیس سننے سے ہی اپنی جورسڈکشن بڑھا رہے ہیں.
سر آپ نے,
یہ آپ کا موقف ہوگا؟
آپ کی ساری ججمنٹس جو ہیں
میں آپ سے اب سوال پوچھ رہا ہوں,
جواب دے رہا ہوں.
ججمنٹ کرنا سوالت ہے.
184(3) کے اندر فنڈامنٹل رائٹس کی وائلیشن بھی سپریم کورٹ میٹر آف پبلک امپورٹنس, اور اگر کوئی قانون مقننہ بناتی ہے تو اس کے اوپر ڈکلیئر کرنا کہ وہ قانون آئین کے متصادم ہے, وہ بھی آپ کا حق ہے انڈر 184(3).
اچھا جب انکم ٹیکس آرڈیننس میں, فیملی لاز آرڈیننس میں جب بھی کوئی امینڈمنٹ آ جائے تو سیدھا سپریم کورٹ میں 184(3) کے تحت ہو سکتا ہے, آپ کا کہنا یہ؟
بالکل ہو سکتا ہے. if my lord,
ٹھیک ہے, یہ میں نے نوٹ کر دیا.
بالکل کریں سر.
even if it's no fundamental right is involved.
نہیں, فنڈامنٹل رائٹس ہو سکتا ہے, لیکن
ٹیکسیشن میٹر میں فنڈامنٹل رائٹ ہوتی ہے.
اگر کوئی امینڈمنٹ بھی چیلنج ہو سکتی ہے, وہاں بھی ہو سکتا ہے, لیکن پبلک امپورٹنس کا ایشو آتا ہے سر. واٹ از دا میٹر؟ دیکھیں دو کنڈیشنز ہوتی ہیں نا سر, پبلک امپورٹنس اینڈ فنڈامنٹل رائٹس.
It's not either or, it is both simultaneously.
وہی میں کہہ رہا ہوں کہ آپ دونوں چیزوں کو دیکھنا ہوگا, صرف فنڈامنٹل رائٹس کو نہیں دیکھنا ہوگا.
تو یہ کیس میں کیا فنڈامنٹل رائٹ ہے بتائیے نا ہمیں.
اس میں فنڈامنٹل to justice کا my lord was saying کہ
کون سا آرٹیکل بتا دیں, وہ والا آرٹیکل رائٹ ٹو لائف.
رائٹ ٹو لائف میں ہولڈ کیا گیا ہے کہ
جی ہولڈ نہیں کیا گیا, اس کے لفظ میں بتا دیں کون سے میں آتا ہے تو میں لکھ لوں.
جی access to justice and independence of judiciary is being held to be incorporated in the words of article 9.
تو آپ کہہ رہے ہیں
literal reading میں تو نہیں ہے, interpretation.
اچھا لٹرل میں نہیں ہے نا, تو یہ تسلیم آپ کرتے ہیں لٹرل میں نہیں ہے, implied reading میں ہے.
نہیں, judgments of the honorable which is binding it says کہ جی access to justice since high court
binding, it may be binding on you not on us.
sir since high court bar کا جو فیصلہ ہے 2009 سپریم کورٹ 879, it is a full court فیصلہ, اس کے اندر لکھا ہوا ہے کہ جی آرٹیکل 9 کی وائلیشن میں access to justice independence.
چلیں ٹھیک ہے, میرا سوال کا جواب مل گیا. آپ آگے بڑھیے, آپ آگے بڑھیں. ہاں
میرے صاحب یہ بتا دیں کہ آپ کریں ایکسیس ٹو جسٹس کی بات ہے, سٹیزن ایٹ لارج کی بات ہے, اس ایکٹ کے تحت وہ کون سی کوئی ایسی پروویژن میں ہے جو پبلک کو ڈبار کرتی ہے ٹو اپروچ دی سپریم کورٹ؟ ایسے کوئی پروویژن ہے جو کہہ سکے کہ
اس میں جو بات ہے انڈیپینڈنس آف جوڈیشری, وی ہیو اے ویسٹڈ انٹرسٹ ان دی انڈیپینڈنس آف جوڈیشری. اف دس لا, اس میں اچھا لا ہوگا, بہت اچھا لا ہوگا, لیکن ایشو یہ ہے کہ اٹ از دا کمپیٹنس. اگر کمپیٹنس نہیں تھی دین اٹس ناٹ اے رائٹ لا, اٹ از الٹرا وائرس.
مینٹینیبلٹی کی بات کر رہا ہوں. اس ایکٹ کو دیکھنے کے لیے ہم نے یہ دیکھنا ہے کہ آیا اس کی پروویژن یا ٹوٹل ایکٹ کسی بھی فنڈامنٹل رائٹ کے اگینسٹ ہے, یا اس کے ذریعے کوئی پبلک یا کسی سٹیزن کا حق مارا جا رہا ہے کہ اسے पहले तो अपील किया थी अब नहीं दिया जा रहा है, पहले ट्रायल किया थी अब नहीं दिया जा रहा है, ऐसी कोई प्रोविजन इसमें है कि हम
सर,
कह सके कि ये इलीगल?
सर मैं कह रहा हूँ इसकी प्रोविजन आपको ये देखनी है कि क्या ये कानून साजी हो
इसके
सकती
जवाब
थी।
दें उसके बाद पहले।
मैं आ रहा हूँ सर, मैं आपको जवाब ही दे रहा हूँ। मैं कह रहा हूँ कि इसमें ये देखना होगा कि क्या कानून साजी का इख्तियार था के पास टू मेक दिस लॉ।
चलिए इसमें बताता
जी।
आपने पहले कहा कि 1980 में रूल्स बने,
जी
वो रूल एग्जिस्टिंग लॉ के तहत बने।
जी।
ये तो आप मानते हैं कि रूल लॉ के तहत बनने चाहिए?
जी।
तो क्या आप
नहीं,
बता सकते
रूल बने 191 के तहत सर,
191
आर्टिकल रूल लॉ के तहत। जी।
आपने थोड़ी देर पहले जो आर्गुमेंट से आपने कहा कि एग्जिस्टिंग लॉज के मुताबिक 1980 में रूल
जी बिल्कुल एग्जिस्टिंग
आप
लॉ।
प्लीज मुझे ये बता दें, मेरी नजर से तो नहीं गुजरे, 1980 में उस वक्त कोई ऐसा कानून था जो सुप्रीम कोर्ट की प्रैक्टिस को
नहीं,
फॉलो करा?
बिल्कुल नहीं
तो
था।
ये रूल कैसे बने?
अंडर 191 56 के बने, पहले बने 1956 में।
लॉ कहाँ गया?
सर लॉ, अगर कोई लॉ है, वर्ड यूजेस सब्जेक्ट टू लॉ। सब्जेक्ट टू लॉ मींस कि कोई लॉ अगर होता, कोई भी लॉ हो, इट कैन बी एनी लॉ, सब्सटेंटिव लॉ।
आई थिंक वो 191 वाला आर्ग्यू आप कर चुके थे, जब आप 175 पे
सब्सटेंटिव
थे।
लॉ
हाँ।
कोई था जिसके वायलेशन में नहीं बन सकते थे,
ठीक।
ये मेरे हम्बल सबमिशन थी।
ठीक
सर।
ठीक ठीक।
तो ये लॉ
आप
प्रोसीजर
अगला पॉइंट बताएं। फिर
अगर
note
कोई
कर लें।
होता-
If I may ask you a
जी।
question. The equivalent to Article 184(3) of our Constitution, I think, is Article 32 of the Indian
जी
Constitution,
मालूम,
which guarantees the right to move the Supreme Court for violation of fundamental rights. If memory serves me right, Mr. Ambedkar, who is regarded as the father
जी।
of the Indian Constitution, in relation to this jurisdiction conferred on the Supreme Court, said it is the very soul of the Constitution.
जी
Now, if that is correct, and in India no one has ever doubted that that is correct, we are here talking of the very soul of the Constitution.
yes, and
It seems to me that, and this is my question to you, that can a challenge to a law which, according to you, whether right or wrong, that's yet to be decided, that is an assault on the independence of the judiciary. Is that not an assault on the very soul of the Constitution?
of course, because
Can it be therefore put to one side simply by saying that it is not in violation of fundamental rights?
no, because
This
my
is
humble
the-
submission is that this is what my humble submission is, that the very purpose this law, and I read that judgments, that it affects the separation of doctrine of separation of powers. My law, this court has the exclusive jurisdiction.
चलिए,
to-
ये point आप repeat करते
Yeah.
रह रहे हैं। अगला
And
point
that's
बताइए।
why if any law which is made in violation of that cannot be, that affects the even the
Okay, let's
fundamental
get on,
rights of the
get
people of
on with it,
Pakistan and
Mr.
access to
Zuberi.
justice.
Next point
जब
पे आ
180 sir, 184 की जो power, that's the original power of this court. There's appellate power is 185, sir. Advisory power is 186. Review power is 188. These are the four powers which are given by the Constitution.
No, no, you are wrong. There are other powers also.
I'm talking about these are the appellate men की बात कर रहा हूँ, चार powers की जो दी हुई है. Now, the original framing में appeal का right नहीं था. Appeal is only provided under Article 185. Now, if you want to give an appeal, my humble submission is that you have to amend the Constitution. And why? Because section आप पढ़ेंगे sir, Article 175, 142 देखा. अब entry 55 देख लें sir. What does entry 55?
हाँ, पढ़ें.
जी. My lord, 175(2), Article
हाँ, पढ़िए,
142A and
पढ़िए।
entry 55 have to be read together, not in
पढ़ने 55 से कहाँ से शुरू करना चाहते हैं?
jurisdiction powers all courts except the Supreme Court with respect to any of the matters list and to such. Now, I'm coming to emphasize on this last part, sir, the second part of this entry. And to such extent as expressly authorized by or under the Constitution. Now, these are very important words, and my lord, I'll keep that my lord's thing. And by or under the Constitution, the enlargement of the jurisdiction Supreme Court and conferring thereon of supplemental powers, sir. The point is that the thing, पिछले जो आपके जो लिस्ट थी, उसके अंदर ये words नहीं थे. In the 56 Constitution, 62 and 72, expressly authorized by.
पढ़ लिए, अब आप argument develop करें.
Argument is that when you read all these provisions together, no court shall have jurisdiction except provided by Constitution or law. The 142, जो Parliament can make laws in regard for. यहाँ increase की जो बात हो रही है, उस पे मैं सिर्फ एक पैराग्राफ जजमेंट.
इसके power increase हो रहे हैं.
On the Supreme Court की power, यहाँ आप
इसमें आप कह रहे हैं ये independence judiciary खत्म हो रही है क्योंकि power increase हो रहे हैं.
Sir, it is the method, the methodology.
फिर वो method वाला argument खत्म हो
नहीं
गया
सर,
ना.
इसमें यही है
अब आप दूसरी
आपकी ओरिजिनल jurisdiction के अंदर अपील नहीं provided थी on the original framers of the constitution. They did not provide. Only the appeal was.
भाई मगर मैं फिर उसका काउंटर आर्गुमेंट
जी,
ये
सर,
भी
मैं-
दे सकता हूँ कि 184(3) का इस्तेमाल जिस तरीके से
सर, वो
किया
बिल्कुल
गया
मैं agree
नहीं
करता हूँ,
देखिए
गलत
ये
हुआ।
आप नो
जी।
सॉरी टू से
जी।
इफ somebody albeit person not even fully authorized is doing something to help the nation, help the Supreme Court, you should say strike down because they're not following some perceived letter of the Constitution. That will be a stretch. If this power had been given to the Federal Shariat Court, if it had been given to some secretary in the government or to the parliament even, then you could say yes. We एक appeal दे दी, in a fit of rage, a judge says, so and so political party, I hereby ban it. खत्म. कोई solution नहीं है इसका, except review, right? You know, in a fit of rage, या आपकी बात किसी को पसंद नहीं आई या कुछ मिसगी हो गई, हो जाते हैं, इंसान दोनों तरफ होते हैं, तो हम यहाँ बंद करके वो फरिश्ते नहीं बनते, हम इंसान ही रहते हैं, फिट ऑफ रेज में उन्होंने कर दिया ये, तो कोई इसका सोल्यूशन ही
सर
नहीं।
मैं कहता हूँ आप बिल्कुल होनी चाहिए राइट ऑफ अपील, बिल्कुल होनी चाहिए, इट्स ओनली द मेथड, बिल्कुल होनी
तो
चाहिए।
मेथड आप
जी,
मेथड
मैं
विल नॉट,
आपको हमें तो हम कॉन्स्टिट्यूशन पे
it's like a patient dying on the, it's like a patient dying on, सुन लीजिए, patient dying somewhere, a person received a gunshot wound, he is lying somewhere on the street, ठीक है? Now, someone is not a doctor, but knows a little bit of medicine. He does something, tries to press him thing. Ideally, it should be performed by the doctor. So he said, no, don't do it. Wait for the water to come, wait for him to die. And he, of course, he's not a doctor. He may be a quack, or he may just have seen some television shows, and he may just be applying some first aid, medical trade, who's not a doctor at all, not even a nurse, to save the person. So, इसमें ये बात हमें बिल्कुल इसको पास कर दें इसका। आप फिर शुरू में तो आप लोगों ने अटैक कर दिया था इंटेंट ऑफ पार्लियामेंट पे, तो मैं तो कह रहा हूँ इंटेंट ऑफ पार्लियामेंट इज गुड।
तो मैंने इंटेंट ऑफ पार्लियामेंट को नहीं
नहीं,
किया,
इस साइड से लोगों ने किया है, उन्होंने कहा
लोगों
जी
ने किया,
पर्सन स्पेसिफिक लॉ है, हमें बता दें पर्सन स्पेसिफिक कैसे है।
cannot be debated here. I
तो
never said that. I said that this law may be one of the good laws. But the point is that the way it has been done is unconstitutional. That is my case before your lordship, my humble submission. और देखिए आप बिल्कुल सही कह रहे हैं कि जी
The question is where the Constitution has put up a scheme of separation of powers as to who can do what. There is a reason, there is a rationale, and there is a philosophy behind it which has been developed over centuries of jurisprudence. If we open the door, and this is a question of opening the door, we open the door for the Parliament to interfere in every matter that the Supreme Court may or may not take up, then there is no end to it. There would be good legislation and there would be bad legislation. How do you differentiate? The differentiation is put in the Constitution by the framers. This is what you can do and this is what you cannot do.
Yes.
Whether you want to do something good, if the Constitution prohibits you to do it, and the Constitution does not totally prohibit you. It says if there is something which should be in the Constitution is not immune from being amended to do that good.
Yes.
But to confer this power on the Parliament and say whatever you do, even if it is beyond the Constitution, if it is good, it's good. That is not how constitutions work.
Yes. My humble जी
देखिए
इसमें
एक सेकंड ठहरिए ना, ये जो रैशनल जो है हमारे रैशनल और रीजन और फिलॉसफी जो होती है, we tend to forget when there's trampling of boots. Then all these things, nice philosophies go out the window. The only difference between a constitutional amendment and a law, the only difference is a numbers game. Do you have 2/3 majority? It's the very same persons doing the lawmaking, the same parliamentarians who are making law. It's no difference, it's just a question of numbers. Suppose a political party comes to power, on the pledge, they're going to provide 184(3). They win the election. They don't have the numbers. Two-third majority. So they are helpless. Even though it was a pledge to the nation, we'll go, the first thing we're going to do is do this. So at the end of the day, it's a numbers game. But if it's a numbers game, then we should also realize the traumatic history of Pakistan. irrespective of numbers, irrespective of the entire nation, one person comes, and then Parliament is held at whatever it is held at, and 269, 270, 270 AA, and everything is done is all right. It's a rubber stamp, done illegally, endorsed by Parliament by amendment to the Constitution. That's all right. We forgo the history. Bhai, America mein ye cheezein nahi hoti. When we are so particular about the full stops and the commas, then we should also say it has not yet happened in America. It may happen tomorrow. It has not yet happened in the UK other than Cromwell. So we should not forget. We should keep in mind the history of the nation also, which is a very fragile history. It's half a country today because of these acts. So let's not cripple the Parliament completely when they are doing good because they don't have the numbers, 2/3 majority. That's all the argument is left with. 2/3 से कर लें, ठीक है? आपका एक वोट कम है, आप नहीं कर सकते हो.
That's what
it boils down to that.
Sir, my lord, to defend, protect and preserve the constitution. If the constitution
For the people of Pakistan.
if that is the thing that
फिर हम आपसे वही सवाल पूछेंगे कितने लोगों ने किया है इसको.
then constitution gives a mechanism, a procedure. You can, my lord, with utmost respect, it is not a numbers game. It is a constitution put, the framers said that if a constitutional amendment has to be made for the people of Pakistan, because they are representing where the independent judiciary will be fully secured, then you have that number games. It is the constitutional requirement,
आप
sir.
तो हैं सिर्फ आप सिर्फ you were not agitated enough either to vote in to have filed your own petition. You have filed your own petition,
No,
or
sir.
you're on notice.
Notice, sir.
ठीक है, so you were not agitated enough to have filed your own petition. ठीक है, some people came and filed their own petition. So if you were so agitated, you should have done it the very first day yourself.
Sir.
Supreme Court, it would have been very nice to see Supreme Court Bar
Sir, जो
Association.
cases file के वो तो take up नहीं हो रहे जो Supreme Court
अब वो क्यों नहीं हो रहे हैं take up? क्योंकि आप ये केस को खत्म ही नहीं करना चाहते.
बात नहीं है सर.
खत्म करें.
बात जी election petition pending
The
है.
Constitution says, the Constitution says, we,
The people of
ये excuse me
Pakistan,
जरा हमें भी
give
question करने का
ourselves-
time दिया जाए.
give ourselves
After-
the following Constitution.
जी.
Now, the people of Pakistan have said, if we want to amend the Constitution,
जी.
we
We-
would do it through our
चलिए ठीक है, ये
representatives.
आर्गुमेंट हो गया, आगे बढ़ते हैं. हाँ. चलिए ठीक है, समझ गए 3/4 का आर्गुमेंट. चलें आगे बढ़े. हाँ.
Mr. Zubairi,
क्या मैं सवाल कर सकती हूँ? Excuse me.
जी पूछिए जैसे.
My lord.
जी, the act says that subject to constitution and law, they have amended either taken the power of the Supreme Court by making rules. So what article of the constitution they have referred to? They have referred to.
They have referred.
Amendment has been made.
जी.
We are opening the doors
जी बिल्कुल सही.
in future for amending the constitution.
My humble submission is Article
simple majority.
175(2) has been read in isolation to amend this law. Basically, an amendment has been done in the Constitution by amended by 175(2). And my humble submission is 175(2) cannot be read in isolation. It has to be read with Article 142A and anti-55.
अगला point बताएं,
जी, एक
note
point is
हो चुका है.
Mr. Zubairi, if I may,
Mr.
Mr. Zubairi,
My lord.
Mr. Zubairi, may I ask you and follow up on what my learned colleague has said, that when Constitution is being amended, it is constituent power that is
Yes.
being exercised.
My lord.
It is a unique power, quite separate and different from the
Legislative.
other legislative competence that is available to Parliament. So I think what my learned colleague is saying is, if we open this door
जी.
of an indirect amendment to the Constitution, we are allowing
Floodgate.
constituent power. It is not a numbers game, if
जी.
I may
Yes.
say so, with all due respect.
जी.
It is a numbers game because it is constituent power. We are allowing constituent power to flow into a channel which the Constitution prohibits
जी.
directly or indirectly.
जी.
So therefore, I think the point that my learned colleague has made, that this is at most, or at worst perhaps, an indirect amendment of the Constitution, which is perhaps barred by the Constitution
Sir,
itself.
tomorrow if this law
नहीं tomorrow नहीं, अभी हम यही देखते हैं.
if this
नहीं,
law
अभी-
is
अब ये
upheld,
बिल्कुल
for
हम नहीं
example,
करेंगे.
then the Parliament can
No,
also
no,
decide
no,
that the
no,
last-
no,
the junior most
no,
judges will
no, no,
जी.
no.
जी.
Zubairi
Yeah,
साहब,
you cannot, you have a particular case, argue that. What happens tomorrow, I am not one who gives judgments on the basis of समाइजेस इस पे कर लें, आप बहस खत्म कर लिया, आप वही पॉइंट बार बार दोहरा रहे हैं।
मेरे साथ
जरा जल्दी खत्म कर लेना, आपका वक्त निकल जाएगा
You are
दूसरों का।
representing the Supreme Court Bar Association. You're not petitioner nor respondent. क्या आप ये बेहतर नहीं था कि आप आके कहते हैं कि जनाब इस एक्ट को पेश करने की जरूरत क्यों महसूस हुई? मेरे ख्याल में जरूरत इसलिए महसूस हुई कि हमने 184(3) के पावर्स कॉन्स्टिट्यूशन से हटकर इस्तेमाल किए, क्योंकि अगर आप इसकी वर्डिंग पढ़ें उसमें सिंपल बात यह है, फिर से अगर आप पढ़ लें, मैं पढ़ता हूं आपके लिए, विदाउट प्रेजुडिस टू द प्रोविजन ऑफ आर्टिकल 199, द सुप्रीम कोर्ट शैल, if it considers that a question of public importance with reference to the enforcement of any fundamental right conferred by chapter 1 of part 2 is involved. हमने जो ऑर्डर्स किए, हम तो लोगों को सजा भी देते हैं, हम लोगों को बरी भी करते हैं, चीनी की कीमत भी मालूम करते हैं, बहुत सी चीजें करते हैं। क्या ये अगर हम अपने इस डोमेन में रहें तो किसी लॉ या रूल की जरूरत पड़ेगी? मेरे ख्याल में नहीं।
सर आप सही कह रहे हैं, लेकिन मेरा ये नहीं है, ये मैं कह रहा हूँ कि जी ये आप पावर बिल्कुल आप सही कह रहे हैं, गलतियां की होंगी, लेकिन पार्लियामेंट उसे सही नहीं कर सकती इस लॉ के थ्रू। दैट इज माय केस। अगर आप करेंगे तो आप खुद करेंगे सर, ये अपने रूल्स में अमेंड करके सर।
इसका मतलब कॉन्स्टिट्यूशन से बढ़कर पावर
नहीं, आप अपने रेगुलेट करेंगे अपने रूल्स और प्रोसीजर को। गलती अगर आप कहें तो आप उसको करेक्ट करें, आप उसमें रूल्स अपने रूल्स अमेंड करें, उसमें आप
अच्छा चलें, आप इस बार यू आर रिपीटिंग योरसेल्फ। अगर हम किसी और को मौका देते हैं, यू जस्ट रिपीट। नहीं, यू वांट टू कैन इफ यू रिपीटिंग योरसेल्फ विल आस्क हियर समवन एल्स।
184(3) is original jurisdiction
जी,
conferred by the constitution,
जी,
and it is the original jurisdiction, and if appeal is given, that would continuation of the proceeding before the original court.
जी।
This is settled
You
law.
will have a super
It is settled
Supreme
law.
Court. जी,
Any provision of the constitution where appeal is given by a simple legislative power by the parliament, that is permissible under the law.
no, my lord, under the constitution it is not, sir. That's my. And may I just quickly take a lordship?
Saab, how would you explain enlargement of jurisdiction?
Yes, I'm coming to that.
And conferring supplemental
Yes, my lord.
powers.
जी, जी,
Because you see, to be interpreted liberally
जी।
as already laid down by this court.
Number of cases, sir. My lord, humble से एक आप करके फिर खत्म करूंगा।
डायरेक्टली उस पे आ जाए ना
जी।
if the
सर
parliament
मैं
is
कह रहा हूँ कि जी
competent to
पार्लियामेंट
enlarge the jurisdiction
जी enlarge
and also to confer any supplemental
yes
power.
my humble submission is अपील जो पार्लियामेंट ने दे दी इसके अंदर, तो कल किसी चीज को भी अमेंड करके सुप्रीम कोर्ट को दे सकते हैं।
आप देखें ना, पहले इसको तो जरा
रूल
kindly
50
explain कर दीजिएगा। अगर तो वो jurisdiction expand कर सकती है पार्लियामेंट, तो फिर उनका इख्तियार है।
नहीं सर, with utmost respect, sir.
How do you read
जी,
this?
I'm reading. I'll take help from a judgment of this court, 2000 SCMR, page 567, and the relevant portion is at page 617, sir. And let's read this paragraph to answer your lordships and my lords. 2000 SCMR, page 567, Province of Punjab is the National Industrial Cooperative Credit Corporation. इसमें through a provincial law, appeal was provided to the Supreme Court. That was struck down. Though a judge, or cooperative judge, was a judge of the Honorable Supreme Court, that was said that is fine. But when the appeal was granted, it was struck down, and this is what the Honorable Supreme Court had. My lord, kindly see page 617, para 17.
Page 6.
617, my lord. Starts at 567 and page 617. And the appeal के बाद may I just read? We lost a page. Coming now to the present Constitution of 1973, it may be of the para 17, sir. It may be observed that according to the Learned Council for the Government of Punjab, in view of Article 175(2) of the Constitution, under which jurisdiction can be conferred on any court, including the Supreme Court, by or under any law, in relation to matters in respect of which provincial legislatures have power to make laws, including cooperative societies, additional supplemental jurisdiction or powers can be conferred on the Supreme Court by provincial legislatures. The law mentioned in Article 170 includes a provincial law and additional supplemental jurisdiction on powers and form an appeal to the Supreme Court under Section 22 of the Impunity Laws being conferred on the Supreme Court in respect of a matter which the provincial have exclusive jurisdiction under the Constitution to enact laws. Now, since judgment is quoted and the finding of the court at the bottom of the page. In view there is no ambiguity interpreting entry 55 of part 1 of Federalist Legislative List 4 Schedule of 73 Constitution. Entry read with Articles 175(2) and 142A of the confers exclusive powers on the Parliament make laws for enlargement of the jurisdiction of the Supreme Court or conferring on its supplementary powers. If entry 50 was not there in the federal legislatures, it could be argued that under Article 175(2) of the Constitution, in respect of matters relating to corporate societies exclusively falling under the comprehension of provision, a law can validly be made by a provincial enlarging jurisdiction of Supreme Court and conferring on its supplementary power. But Article 175 is not to be interpreted in isolation. It has to be read and interpreted along with Article 142A and entries in the legislative list. Under entry 55 of the Federal Legislature is competent to make laws regarding jurisdiction.
Actually, you are not reading the relevant part. The relevant part are 2 lines.
जी.
The last is 616 पे last line पढ़ लीजिए, and the 2 lines following that. That's what is the answer to the question. 616 की last line पढ़िए page पे.
From the aforesaid.
हाँ.
From the aforesaid entry, it follows that under the interim constitution, additional supplementary jurisdiction could only be conferred upon by a law made by. Yes, sir, interim constitution.
आप पढ़ तो लेना, provision तो वही है ना.
जी.
By a law by the federal legislature.
नहीं सर.
वहाँ issue सिर्फ इतनी सी थी. जरा समझने की कोशिश करें ना. आप जरा सुन तो लीजिए ना हजूर. वहाँ सिर्फ ये बात उन्होंने कही. जी सूबाई उसको पावर नहीं है और स्पेसिफिकली ये जुमला इस्तेमाल कर दिया फेडरल लेजिस्लेचर कर दे तो वो प्रोविंशियल बात तो हम भी मानते हैं मतलब मैं कम से कम मैं तो बिल्कुल आपसे एग्री करता हूं इस बात पे
उसकी एंटी 55 में एनलार्जमेंट की बात नहीं की हुई थी 72
की आप जुबैर साहब
जी इसको पढ़ लूं सर प्लीज
सर अभी एक मिनट मैं आपसे इसके 4 लाइनें पढ़ लीजिए उससे पूरा जवाब आ गया इसमें 618 पेज पे आइए
आ रहा हूं उसी
फर्स्ट पैराग्राफ
जी
लास्ट 4 लाइंस हाउएवर से पढ़ दीजिए आप
सर मैं यहां इसके ऊपर भी बड़ा इंपॉर्टेंट
पढ़ दीजिए वो
इसका आ रहा हूं जो माय लॉर्ड्स क्वेश्चन वाज
अच्छा फिर आप फिर छोड़ दीजिए फिर हम अगर आप समझते हैं आप शाम तक चलाएंगे इसके
नहीं सर बस मैं
सुबह से
ये
आपको दे रहे हैं टाइम
2 लाइनें
तो ये हाउएवर से पढ़ दीजिए ना दैट
लंबे लंबे पैराग्राफ पढ़ेंगे
दैट इज द क्रक्स हाउएवर से पढ़ दीजिए
However, jurisdiction of Supreme Court can be enlarged. Supplementary powers can be conferred on Supreme Court by law in view of Article 175(2) of the Constitution, NT 55, read with Article 142. Leave no that the enlargement jurisdiction confers supplementary powers can only be done through law made by federal.
लेकिन ये है सर लेकिन इसका ऊपर वाला रेशियो ऑफ द जजमेंट
ये रेशियो है
बस
तो रेशियो ऊपर भी है सर
अच्छा अच्छा अब आप हम आपको खत्म कर रहे हैं
सर एक मिनट सर एक मिनट
आपने पढ़ा है दिस इज द मेयर रीस्टेटमेंट ऑफ व्हाट इज रिटन
हम पढ़ लेंगे ना यार देखिए ये हमारा काम नहीं आप हमने बता दिया हमने नोट कर लिया
असल उसका क्रम वो
अच्छा अगर आप सॉरी टू से अब हमें एक ही इंप्रेशन मेरे जहन में क्रिएट हो रहा है कि आप चाहते हैं कि 184(3) के केसेस जो लगे हुए लगे नहीं कोर्ट में क्योंकि आप चाहते हैं केस खत्म ही ना हो कभी तो बस आप खत्म कर दीजिए ना हमने आपने बता दिया हम पढ़ लेंगे शुक्रिया
मैं कह रहा हूं आइसोलेशन में नहीं पढ़ा
अच्छा अब आप कोई और पॉइंट है तो हम सुन के आपको दोबारा नहीं सुन रहे हैं
दूसरा पॉइंट जो है कि जी इसके अंदर रिट्रोस्पेक्टिव इफेक्ट दे दिया 18 सेक्शन 5 के अंदर कि जितने केसेस हैं वो सब खुल सकते हैं
पहले जरा क्लैरिफाई कर दीजिएगा
जी
ये जो रिट्रोस्पेक्टिव इफेक्ट है ये सिर्फ 184(3) के लिए है
जी
अगर किसी ने 188 के तहत रिव्यू एक्सरसाइज कर ली है उसके लिए नहीं है देयर इज नो अपील अगेंस्ट रिव्यू सो देयर वुड बी हार्डली एनी केस लेफ्ट फॉर दिस अपील टू बी एक्सरसाइज
ठीक है सर आप सही कह रहे हैं लेकिन पॉइंट इज दैट giving of power who can give that power appeal
आप बता देना उसका इफेक्ट क्या है
इसका इफेक्ट ये है कि
hardly any effect
सर मुझे नहीं मालूम
because it is not a power against a review
I am not there to say कि कितने केसों में रिव्यू हुआ है नहीं बास केसों में नहीं हुआ होगा रिव्यू उसके ऊपर तो राइट खुल जाएगा फ्रॉम 1973
तो आपको घबराहट क्यों है हमारे काम बढ़ जाएगा ना
घबराहट की बात नहीं है
मैं समझना चाह रहा हूँ सिर्फ
ये केस घबराहट से आर्गुमेंट नहीं है आप कॉन्स्टिट्यूशन या तो प्रिवेल या नहीं करेगा अब वी हैव नो टू वेज आइदर द कॉन्स्टिट्यूशन के
ठीक है बार-बार ये बात रिट्रेट ना करें
नहीं समझ गए कह रहे हैं घबराहट तो नहीं हो रही सर घबराहट तो नहीं हो पॉइंट इज दैट कि आइदर कॉन्स्टिट्यूशन इजाजत देता है या नहीं देता ये कॉम्पिटेंस है या नहीं
सुन ली बात है ना बार-बार कहने से कोई फर्क तो नहीं पड़ता है ना खत्म अब हम अगले जो होंगे सुनेंगे उनको अगर उनको आपको 20 मिनट सुनेंगे ठीक है
थैंक यू सर
विश्व की तो से दो हैं
हाँ इस पे ठीक है वही अपील कर दे ठीक है हाँ
घबराहट की हालत है
मैं कह दिया ना, सुना दिया ना मैंने.
सिर्फ आपका
डिस्काउंट्स एंड डील से छोटे मोमेंट्स को बड़ा बनाता है मेरा पेपाक कार्ड. अपने बैंक से पेपाक डेबिट कार्ड नाम लेकर तलब करें.
हमें कहा कि हाँ बुध को आप कर सकते हैं, अब कल पे चला गया और वहां पूरा स्टेज सेटअप करना है सिर्फ इसलिए कि किसी ना किसी तरह इनका कैंपेन भी रोकी जाए, ये इलेक्शन ना कर सके, इनके लोग भाग जाएं, सीनियर लोगों को डरा दें. तो पहले तो मैं अपनी अदलिया देखें, हमें होप सिर्फ इस वक्त पाकिस्तान की अदलिया से है, हमारी ह्यूमन राइट्स की हिफाजत करें. लेकिन मैं आज से सारे हम इन सब सबूत इकट्ठे कर रहे हैं. जिस तरह का इन्होंने जुल्म और तशद्दुद किया लोगों पे, हम सारे सबूत इकट्ठे करके ये सारे इंटरनेशनल ह्यूमन राइट ऑर्गेनाइजेशंस को आज हम भिजवा, यूरोपियन यूनियन को अप्रोच कर रहे हैं. मैं सारे जो ओवरसीज हमारे पाकिस्तान तहरीक इंसाफ के चैप्टर्स हैं, आप सारे वहां जाके पॉलिटिकल जो पॉलिटिशियंस हैं मुकामी, सबको बताएं कि ह्यूमन राइट्स जिस तरह की वायलेशंस आज पाकिस्तान में हो रही हैं, इसकी कोई मिसाल नहीं. हमारी जमहूरियत को कत्ल किया जा रहा है, किसी को आइन की फिक्र नहीं है. अभी तक जो इलेक्शन करवाना था, मुझे बताएं 30 अप्रैल को इलेक्शन है, तो यहां तो कोई इलेक्शन की फिजा ही नहीं बनने दे रहा है. पहले हमारी रैलीज के ऊपर अटैक कर दिया जो पहली दिन थी, उसके ऊपर उन्होंने जिस जिले शाह बेचारा शहीद हुआ, कितने किसको मारा, और अब फिर जो जलसा करना था ओपनिंग, उसके ऊपर वो परमिशन नहीं दे रहा है. तो यहां तो जमहूरियत का कत्ल हो रहा है, आइन का कत्ल हो रहा है. हम इंटरनेशनल ह्यूमन राइट्स ऑर्गेनाइजेशंस को फिर से मैं कह रहा हूं आज अप्रोच करेंगे, फॉरेन कैपिटल्स को अप्रोच करेंगे, अपने पीटीआई के जो चैप्टर्स हैं दुनिया के अंदर उनके जरिए, और उसके अलावा हम अपने ऑनरेबल चीफ जस्टिस आपके सामने जो वायलेशंस हो रही हैं इस मुल्क के अंदर, कोई यहां कानून नहीं रह गया, जंगल का कानून है, माइट इज राइट, उसके मुताबिक इस वक्त यहां हर किस्म का हरासा खौफ फैलाया जा रहा है. उसके बाद एक और कोशिश क्या हो रही है कि यहां हमारे एक तकसीम करने की कोशिश हो रही है. पहले तो जो यहां हमारे वर्कर्स पश्तून जो भी हमारे साथ आए हुए थे, उनको तालिबान डिक्लेयर करने की कोशिश की है कि जी ये कोई दहशतगर्द है, उनको दहशतगर्द बनाने की कोशिश की है. इंतशार फैला रहे हैं कि सारे हमारे रिएक्ट कर रहे हैं जितने पश्तून हैं. किसी को अभी कहा कि जी दीर में एक तालिबान यहां पहुंचा हुआ था, उसकी दीर से स्टेटमेंट आई है कि मैं ना तालिबान थी, मैं उधर दीर में बैठा हूं, मैं कभी जुबान पाक ही नहीं गया. इस तरह की चीजें हो रही है, डिस इंफॉर्मेशन. इनकी ये कहने की कोशिश कर रहे हैं कि हम इस मुल्क में इंतशार फैला रहे हैं और हम दहशतगर्दी की तरफ जा रहे हैं, और ये जो झूठों की मलका है उसकी तरफ से ये बार बार आ रहा है, क्योंकि वो तो ऐसे फिर रही है जैसे पाकिस्तान उसकी कोई जागीर है, कोई कानून से वो ऊपर है, वो हुक्म कर रही है कि ये करो, उसको पकड़ो, उसको माफ कर दो, मेरा बाप नेल्सन मंडेला है, उसके सारे केसेस खत्म कर दो. यानी उसको तो कोई इशू ही नहीं है कि इस मुल्क के अंदर कोई आइन और कानून भी है. ये जो तकसीम करने की कोशिश है, इंतशार फैलाने की कोशिश है, इसके पीछे क्या है? इसके पीछे किसी ना किसी तरह इलेक्शन में से निकलना है. अगर किसी पार्टी, कोई पार्टी इस मुल्क में आज इंतशार नहीं चाहती, वो तहरीक इंसाफ है, क्योंकि हम इलेक्शन चाहते हैं. जो इलेक्शन चाहेगा वो क्यों मुल्क के अंदर इंतशार चाहेगा? जो सारे रास्ते में कल सैटरडे को इस्लामाबाद जो हमारे ऊपर उन्होंने किया, जिस तरह के रबर बुलेट्स और ये जो टीयर गैसिंग की, जब कोई कुछ नहीं कर रहा.
Remember right after this all collapsed, and then he did like 10 interviews on Good Morning America and 60 Minutes, and everybody's like, why is he's making himself look so bad? I think somebody was.
I said that.
Oh, was it
I
you?
said, yeah.
That you thought that this is going to be part of his defense argument?
This is the defense argument.
Yeah.
Like, I'm a lunatic. I have absolutely no judgment, and I won't even listen to my lawyers and shut up.
Yeah.
I literally said that. I was like, I think that this is part of his, I am deranged. I do impulsive things, and I don't think things through, and I won't even listen to my lawyers. And then when the judge tells me, hey, don't use a computer and don't talk to the press, I'm going to get a VPN. I'm going to use my computer all day long, and I'm going to talk to the press. I mean, not only did he do it before he was indicted, after he was given house arrest, they
he was
had
on
to put
house
him in
arrest
jail.
using a VPN.
This kid didn't know where the lines are, or when he realized he had committed all these crimes, he just said, you know what, I'm going to lean into, I'm a lunatic.
This Week in Startups is brought to you by House of Macadamias is the next big health trend. Get a free month's supply of macadamia milk with any order at houseofmacadamias.com/twist by using code TWIST20. Roots. Invest in the only real estate investment trust that creates wealth for you and its residents at investwithroots.com/twist. And Embroker's Startup Insurance Program helps startups secure the most important types of insurance at a lower cost and with less hassle. Save up to 20% off of traditional insurance today at embroker.com/twist. While you're there, get an extra 10% off using offer code TWIST.
All right, everybody, welcome to Friday. It's Friday, and we're going to do a little Jason Unplugged. Producer Nick is with us. And I wanted, I have such a busy week this week. I've been raising our fourth venture fund. You can read about that at launch.co/memo. And I've just been in a ton of meetings, and that's been amazing. But I am falling behind on the news, and I needed to catch up on this SBF stuff. I started listening to the Michael Lewis podcast, Nick. Michael Lewis is doing like the trial of SBF, but he's not doing it himself. I saw him on 60 Minutes. He's sending somebody to the report, and they were talking about the jury selection process, which I believe started this week. Everybody knows SBF is, in all likelihood, a deranged sociopathic lunatic.
And Michael Lewis's
criminal.
book just came out, Going Infinite, where he covered
Going
SBF.
Infinite.
And
Yeah.
he's created a little bit of controversy because he's one of the only people that doesn't think that SBF is a deranged sociopath. He's sort of gotten roasted a little bit because he's sort of defended SBF.
Oh, no, he's definitely defended SBF. He said on 60 Minutes that SBF had a real business. He was the casino, and that the FTX exchange was printing money and was a very real business. And he said if it wasn't for Alameda, which he should have shut down, there would have been no problem here. Of course, that's like saying, like, Al Capone would have been fine if it wasn't for the
If he never
murder.
killed anybody. Yeah.
And if it wasn't for the murder and the rum running and the gambling and this ring and that ring. Extortion, loan sharking, whatever. So sure, yeah, he wasn't a criminal if he didn't do the criminal stuff. But obviously, listen, he's got to have his day in court. And here we are, it's his day in court. But yeah, bad look for Michael Lewis. But I'm a huge fan of Michael Lewis, so I'll give him the benefit of the doubt. I understand.
Michael Lewis is like one of those artists that, like sort of like Kanye West, right? Kanye can say a lot of crazy things, still made some of the best music I've ever heard.
Yeah.
So,
I'm
like
with you on
Michael
that,
Lewis,
yes.
I don't even care. I could separate the art from the artist a little bit.
Yes.
He can say whatever he wants.
I can't
wait
to read the book. Yeah.
Big Short, Moneyball. Come on.
Moneyball is such a great film. That's one of the things about Michael Lewis. He's such a good storyteller that the films turn out great. This film is going to be amazing. I'm not sure who's going to play SBF in this, but
Apple bought the rights to it, I believe, before the book even came out. Yeah.
Yeah, makes sense. I'm sure he got $5 or $10 million for it because that's going to be a huge hit. There's going to be a lot of interest in it. But let's get started here. What is happening in the trial?
So the trial of SBF just kicked off this week, and we'll just give you a little update on how it's going. So a quick refresher on the FTX collapse. If anybody forgot, just some of the major players and what happened. So the big issue was that Sam Bankman-Fried controlled both FTX, which is the crypto exchange where users could buy and sell crypto like a Coinbase or a Binance. But he also controlled Alameda Research, which was a crypto trading firm that actively was it's almost like a crypto hedge fund. You can think of it as basically.
So he owned the casino, and then he had a bunch of players in the casino.
Yes,
which is like rule number one of what you don't do. But okay,
yeah. He allegedly told investors that Alameda received no special treatment from FTX. That's actually what one of the investors of FTX testified, one of the Paradigm founders. FTX, now this is where it gets really gnarly and where all of the alleged fraud and crime. Oh no, I don't know if we have to say alleged because some of the his co-founders already admitted to fraud and flipped on him. So I don't know if you have to say alleged there. But
yeah, that's it's alleged he did it, and I guess for those folks they have admitted guilt. So that would be, I think, the proper hygiene as a journalist. He has denied it. His co-founders or his compatriots have admitted it. So we're in process. It would be as if, somebody, the accountant working for Al Capone says, we committed crimes, but Al Capone is still saying he's innocent.
Right.
Or in the Trump case, like people are starting to flip on Trump and they said, we committed crimes, but Trump is saying, I'm being railroaded, right? So you got to give people the benefit of the doubt. I believe in that, although it's not looking good here.
So FTX had its own native token, which was called FTT. It's like a platform token. So if you wanted to transfer funds from your FTX account into the FTT token just to hold it and then transfer it back into another crypto, that's sort of what the token was. It was basically buying that token was a bet on FTX's platform.
Right.
FTT
but it was not, just so we're clear, FTT was not a stable coin.
No.
It's not Tether, which has its own reputation issues, and it's not USDC.
It was not
right?
pegged against any dollar.
Yeah. Okay. Great. It was pegged against nothing.
FTT was majority owned by Alameda and FTX itself. So only a small percentage of FTT actually was traded publicly. It had a very small float, as we just talked about actually recently with ARM and Instacart and Klaviyo. They all had a very small float, a small percentage of the company that's actively trading publicly.
Yeah.
And what this did, allegedly, was allow FTX to manipulate the price of FTT, thus increasing its holdings on paper. Then,
so if you own 99% of FTT and the public owns 1%, and you start trading between your own accounts, you could paint the tape, create a bunch of trades, fake trades, wash trades, whatever you want to call them, and then, have Alameda or FTX or whoever, individuals, buy FTT from each other at increasingly high prices, and then the public gets some benefit from it, but they only own 1%. So if it goes up 10%, the majority of that value accrues to the 99% holder. I'm making numbers up here, but yes, that is a classic technique.
So their FTT would increase in value as they inflated it, allegedly. Then FTX and Alameda would use these inflated tokens as collateral for loans between the two of them. So allegedly, Alameda would acquire FTX customer deposits to trade by loaning FTX its worthless FTT tokens as collateral, if that makes sense. I know there's a lot of letters and numbers and nonsense there, but
the two entities would use the FTT tokens as collateral, which would be like, if you and I were like, hey, I've got this imaginary, paper over here, this magic paper that's worth $1 billion, and we would give each other loans based on it. Or I would say to you, oh, I'll give you a loan against your house that's worth $100 million. You'd be like, okay, I'll give you a loan against your house that's worth $1 billion, which is exactly what they're trying to get Trump for in this New York case, inflating the asset value. So if you inflate the asset values and take a loan against it, right? Which is a fancy collateral, is a fancy way of saying that, it's what you get if the loans don't get paid back. But if the loans are not forced to be paid back between these two parties, then it never becomes due, basically. So feels like we're getting towards the Ponzi allegations.
Yeah. So then it all came crashing down, starting in FTX somehow withstood all the crazy BlockFi going out of business, 3 Arrows Capital. They withstood all that, right? And everyone was like, wow, how are they doing this? And then finally, in November of 2022, someone at CoinDesk got a leaked basically balance sheet of Alameda, and it saw that a ton of Alameda's holdings were FTT. They reported that, and then CZ from Binance, who was the big rival of SBF, tweeted that Binance was liquidating all of their FTT tokens. That caused a sell-off of the public FTT tokens, which crashed the value, and then that eventually caused FTX to go insolvent. So that was basically, in sort of a high-level way, what happened.
So and now CZ cleared some large amount of selling. Like, he was the winner in all this. He owned some percentage of FTX, I believe, and he sold it.
Yes, he sold it then, before, though, I think, like a year before this all happened.
He had sold it before earlier, but he owed some FTT tokens. He started selling them. And he basically gets to make money and kill a rival. So it's like a double joy for him.
Yes.
Okay, I got a funny story to tell you. House of Macadamias graciously sponsored the All In Summit. And to wow the crowds, they created a special edition salt and vinegar pack of macadamia nuts. And guess what? People went crazy for them. Dozens have been messaging the founder, Brandon, asking him to make the salt and vinegar nuts available on the website. Listen, you've heard me rave about the health benefits of macadamias, but don't take it from me. The most health conscious people in the world are eating them. Dr. Andrew Huberman, I like his podcast. I started listening to it. He mentioned he snacks on macadamias in his GQ profile. And that guy, Brian Johnson, he was on the podcast when he wasn't a health lunatic. He's trying to reverse his aging and he eats macadamias. So all you really need to know, House of Macadamias products are delicious and they support good health. My favorite, dry roasted chocolate dipped macadamias. You know, I get my chocolate dipped in there. And they also have a dipped snack bar. So I put a couple of those in my backpack. I put a couple of them in my little roller. So I have a healthy and delicious snack. I make a better decision. Listen, if I had a candy bar, which, you know, like sometimes I break down and I buy one of those, not a good choice for me. Now I make a better choice. House of Macadamias, they got a new product, macadamia milk. Get a free month's supply of macadamia milk with any order at houseofmacadamias.com/twist. That's a free month supply of macadamia milk with the code TWIST20 at houseofmacadamias.com/twist.
So now that we've covered like the basic of what happened, let's get to the arguments. So the prosecution, which are federal prosecutors, by the way, their general argument is that SBF and his rise to fame as CEO of FTX were built on lies. They're alleging that he stole customer deposits through a secret backdoor to Alameda Research, which was SBF's trading firm. And then with these stolen customer deposits, SBF was able to make investments, buy property in the Bahamas, enrich himself, get stuff for his parents, and all that stuff.
And allegedly, this is how he would have potentially, either from the profits of FTX, which did have some profits because they were taking a piece of every trade, or from this stolen money, or some combination, allegedly, possibly. That's how he signed up all these celebrities, Mr. Wonderful and, you know, whatever, Giselle and everybody they gave money to buy Super Bowl ads. Tom.
पुरअमन चले जा रहे थे इश्तियाल फैलाने की कोशिश है किसी तरह इंतशार फैले लोगों को जोश आए वो वापस रिटेलिएट करें कोशिश सिर्फ ये है यहां भी आके ये जो इन्होंने घर पे किया है दीवार तोड़ दी दरवाजा तोड़ दिया चीजें लूट के ले गए क्या इससे लोग जो देख रहे थे उनके ऊपर क्या गुजरी होगी सारों को गुस्सा तो है मैं बार बार लोगों को कहता जा रहा हूं कि हमने किसी किस्म की वायलेंस में नहीं हमने किसी किस्म का हथियार नहीं उठाना हमने कभी कोशिश करनी है कि हम पुरअमन रहे क्यों क्योंकि हम तो इलेक्शन से आ रहे हैं जो इलेक्शन से भाग रहे हैं वो ये पूरी कोशिश कर रहे हैं तो इसलिए मैं ये वाज़ेह करना चाहता हूं पहले ये जो इंतशार की बात है ये मैं क्लियर कर दूं तहरीक इंसाफ का कारकुन नहीं चाहता वो इलेक्शन चाहता है वो इस मुल्क में तसादम नहीं चाहता और दूसरी चीज जो तकसीम करने की कोशिश की जा रही है हमेशा